So we had filed our rejoinder affidavit filed by the government respondent. So my humble prayer is that let the matter may be fixed for admission hearing of this case.
You have filed a rejoinder affidavit.
Rejoinder affidavit
It's already fixed for admission.
for on 4/4/2025, your lordship.
So this is fixed for admission. So we'll hear on admission and we'll dispose it off
Right.
today or some other day.
Some another.
Okay. All
My
right.
land at Sino is there. I have to be.
Let it be fixed on 6th, my lord. 6th of April
No, after
or
Bihu,
7th of
lordship.
April.
Lordship, I beg to mention for after Bihu, lordship.
After Bihu?
It's not hurried. Nothing has been.
On 21st then.
All right, 21st.
The 21st
Learned
of
Counsel Dr.
okay.
B.N. Gogoi is present for the petitioner and submitted that a rejoinder affidavit has been filed for the petitioner. Okay. Comma, learned senior counsel, no, Mr. J.
My lord.
Mr. J. Roy is present for respondent number 1 and 2. And learned counsel, Mr. C. Chakraborty.
KK Bhattacharya.
Huh?
KK Bhattacharya. KK Bhattacharya.
Your name is not in the cause list.
No, I'm appearing for the
First time?
state of Assam.
Oh, sorry. Government advocate. Okay. Learned government advocate, Mr. K.K. Bhattacharya is present for respondent number
3, 4, and 5.
3, 4, and
State of
5.
Assam.
Comma, state of Assam. To submit this matter for admission on 21st. Okay.
Obliged.
Number 2 and 3.
I'm deeply obliged.
Who are three? Your name?
J. Medi, bro.
A. Medi.
J. Medi.
J. Medi. Learned counsel, Mr. J. Medi, has submitted that an adjournment slip has been
Yes.
circulated, and he has paid for adjournment. Full stop. Please this
Fix the
matter.
date before Bihu, because it is fixed on 23rd of April.
Just Bihu out of the meeting. 7th April. All right.
Deeply obliged.
Item 4. Yes.
This is a regular second appeal. Again, the appeal judgment passed by the learned civil justice court, reversing and dismissing the appeal or decree passed by the learned civil judge junior division justice court. The fact is that actually the petitioner, the present appellant who was the defendant counterclaimant in the lower court, is a renowned businessman of Tesla. And the plaintiff, now respondent, he is the manager of the bank, my lord. Manager of the Punjab National Bank. What happened in the year 2012, that bank manager proposed to sell a plot of land along with the RCC building DRW at a cost of rupees 23 lakhs. Accordingly, agreement was issued between the parties, and after taking money was taken 23 lakhs. But now the present appellant has requested him to obtain the sale permission to issue the execute the sale deed, my lord. But he, instead of executing the sale deed or applying for the permission, has filed a suit against him that he is disturbing me. He is trying to take the possession of my property forcefully, my lord. He has filed a title suit. That title suit was the number 33, my lord. But when the case was going on, he has compromised that case with the petitioner. And that I have compromised it as I have already taken the rupees 33 lakhs from you or 23 lakhs from you. So I compromise it. And I will return the amount after 3 months. If I cannot return you, then you can file a suit for that is the specific performance of the contract, my lord. But after 3 months, he failed to return the amount and told him that he will sell the land, but price should be 36 lakhs, my lord, not the 23 lakhs. So it was settled at 33 lakhs and agreement was executed. It is here. Agreement was executed and the 35 lakhs was paid, including that 23 lakhs. 35 lakhs was paid. And another 1 lakhs will be paid at the time of execution of the sale deed. Accordingly, he has applied for permission of the sale. Permission was granted by the Deputy Commissioner, which is in last page of the, and the price of the property was fixed as 4,50,000, so I got government value. On that government value, the court fee was paid and the sale deed was executed, by the present respondent, taking theme on time to deliver the property, my lord. Execution is complete, my lord. But thereafter, after theme on instead of deliver, where he has repeatedly requested him, my present appellant who repeatedly requested him to execute the deliver the possessions, but he has filed FIR before the police that he is trying to dispossess my property, all this. But police has submitted all the final report, my lord, no case against them. So thereafter, after that, he has filed a case against the present appellant that the for cancellation of the sale deed on the ground that sale deed was forcefully obtained by obtained from me. But he is the bank manager. It is not possible that he is forcefully execute the sale deed. Thereafter, my lord, he has filed a petition that is suit for the cancellation of the sale deed and also permanent injunction and also cancellation of the municipality holding number, all these things. And thereafter, again that my plaintiff has filed that is present appellant has filed a counter claim, my lord, stating all these things that he took 36 lakhs and the sale deed was executed, but he took time to deliver the property. But instead of delivering the property, he has filed this case. And the learned Munshi, after hearing both the parties, has dismissed the claim suit of the petitioner, that is present respondent, and decreed the counterclaim, my lord. That is, it is proved that he took there is an admission also in the agreement. If your lordship say, I can point out it. The agreement of payment of 36 lakhs, alia agreement of payment of 23 lakhs, all these are on the record. Thereafter, he on the ground that the sale deed was they keep the counterclaim that it is proved that the sale deed was executed, money was taken. So counterclaim was decreed, suit was dismissed, my lord. Again, then the plaintiff has filed an appeal before the Lanet Civil Judge. That's proved that in the Lanet Civil Judge Senior Division, what they have done, he has made out a new case here. It is not the neither party case, neither plaintiff nor appellant, and that the sale deed is overvalued or undervalued. There is no put stamp paper, number papers paid on it. But it is the absurdity of what value has been assessed by the government. The stamp paper has been paid on it. If there is a shortage of stamp paper, definitely sub-register would not have executed it until and unless the payment is stamp paper is paid, my lord. So that was not the case of the plaintiff, that it was the undervalue or no value, no stamp paper was paid. This is not the case of the plaintiff, nor anything in the plaintiff, or nor any issue to that effect was. So Lana Civil Judge, the things which are not in the pleading and not in the issue has framed the new suit. That the new case, that the stamp case is undervalued, so it is barred under section 35 of the Stamp Act. But the 35 says that when the stamp paper is undervalued, it cannot be accepted. But here is not the undervalue. Government, what that had been fixed by the government, value was paid on it. Again, if supposing it is undervalued, if it is admitted by the court, it is exhibited and admitted, then appellate cannot raise it under section 36 of the 6 of the Stamp Act, my lord. So the Lana Civil Judge has discussed all these things and ultimately agreed that the error was admitted, so not admitted, and not the question of undervalue cannot be taken in. But now he has come to another point that when the sale deed property of the property sold was not delivered, then the sale is not complete. That is completely wrong conception under Section 54 of the Transfer Property Act. Transfer Property Act defines sale, my lord.
It's okay. It's okay. It's okay. It's okay.
54,
It's
54 the sale value of the sale of the immovable property when the value is 100 rupees or more can be affected by the registered document. It is not that possession should be delivered immediately. But later part.
Where is the finding of the civil judge, in which paragraph?
My lord?
In which paragraph? Finding of the civil judge that the sale was not complete? Appellate court.
Appellate court of the findings.
Okay, I'll come right.
Page 13.
56.
38.
56.
Page, which page and which paragraph?
56, one observation has been given, my lord, page 56.
Page 56.
Page 50, finding of the.
Page 56.
First appellate
Please
court.
read. Please
Para 22 and 23, my lord.
please read it.
56,
Page 56.
56, page.
There's no paragraph 22 and 23 in
No.
page 56.
Uh,
122, 123.
Yes.
Okay, please read it.
56 page.
Yes, please read it.
Okay, 22 and 23 para. 22. However, this could note that the instant case is governed by the exceptions and sign in section 36, which I have already submitted, the under stamp rate section 36. If it is admitted in the under section 35, then on 36 says then it cannot be questioned in the appellate court. So 36 of the stamping as clarified by the Supreme Court and so, that is the since the sale deed, exhibit DL 51 here, my lord, sale deed was admitted into evidence by the learned trial court, that its admissibility cannot now be called into question in the appellate state solely on the ground of the deficiency of the deficiency stamping. So it is clearly stated in the Act, my lord. That has been defined by the learned first appellate court in
Yes,
this year.
yes.
So therefore, this court has an obligation to proceed with the decision on the merit rather than remanding the case. So the question is that indirectly the sale deed, when it was barred by the section 36, this is admitted, and this writing shows this finding. So he is not willing to remand the case to the learner by setting aside the findings, my lord. But now, next question, I am going to the merit of the case. What has come to the merit? Next para, my lord. In doing so, this could accept the principle that the registered sale deed carries the presumption of the execution and validity as recognized by the Honorable Supreme Court and the Honorable Gauhati High Court, including Sunita Rani Nath versus Robindra Kumar Nath AR 2218. However, the presumption is rebuttable on the facts of the present case, the evidence of the possession and the admitted non-delivery of the possessions of the gross undervaluations sufficiently rebut the presumption of the voluntariness of the genuineness. That is that he has come to the question of non-delivery of possession. That means this stamp paper has been indirectly admitted. That is not under value. It is admitted, but has come to the delivery of possession was not made. But as I have already section 54 plus the sale is one part, my lord, and the delivery of possession is another part, under section 55, my lord. This 54. $54, my lord, sale. Sale is transfer, sale is the transfer of the ownership and exchange of the.
No, not required. No,
It is sale. Now, next point, my lord, delivery of possession. The clause, my lord. Clause B, my lord, delivery of tangible immovable properties take place when the seller places the buyer or such person as a direct the possession of the property. So after execution of the sale deed, the seller will have to put the buyer into the possession of the property, my lord. So sale is one part and the delivery of property is another part. Here, what happened after executing sale deed, the plaintiff has, the seller has taken 3 months time to deliver the property, my lord. But instead of delivering the properties, he has filed a suit seeking that the sale deed was forcefully obtained by him. But it is not that the sale deed is invalid because the non-delivery property. Execution part is one part and delivery property is another part, my lord. The section 54 is very clear, my lord. So as the property possession has not been delivered, so he has, instead of delivering the property, he has filed a suit before the.
Where are your substantial questions of law?
Yes, substantial question of law, my lord, as page 14 and 15, my lord. There are so many substantial question of law. page 14, my lord. Number one, whether the learned first appellate court committed a substantial error of law in refusing to act upon the registered sale deed exhibit DL5 solely on the ground of the undervaluation, ignoring the mandatory bar under section 36 of the Indian Stamp Act 89, which precludes any challenge to the admissibility of an admitted instrument, my lord. Sorry, there, as this section 36 is the bar, my lord. Undervalue of the sale deed, when one admitted, it cannot be questioned. But here is not the question of undervalue. What value government has decided? Government has fixed, we paid put fee on it, my lord. Moreover, it was not the case of the plaintiff, nor the case of the defendant, nor any issue was framed on the point of undervaluation, my lord, nor there is anything, any apartment in the pleading. So he has appellate court has made this issue from his own side, my lord. It is in neither party case. Secondly, non-delivery, because of non-delivery sale is included, that is not, that the law is very clear that after execution, delivery is to be made. So number two, whether the first appellate court are in holding that non-delivery of possession renders a registered sale deed void contrary to section 54 of the Trespass Property Act 18(2), which does not make the delivery of the possession of condition precedent for the vesting title, mother. So the delivery of property is to be made later, and he took time to deliver the possession of the property, but ultimately instead of delivering it, as filed suit against him, that the sale deed was forcefully get executed for me, my lord. So he's not a layman to forcefully execute.
All right, I'll read and I'll decide whether there are substantial questions.
Substantial question on that, for substantial question, the appeal may be admitted, my lord, for hearing.
I'll have to read, I'll need
No,
some
yes,
time
sir.
because
When the
there are
substantial
judgments.
question of law is there, your moreover, it is a reversal finding. That is one point.
See, I'll have to go
Not
through
the content
judgments.
finding. No, other side will be hard at time of final hearing, my lord.
I am not going to hear the other side.
No, these are.
I'll read
my-
it.
Yeah, I understand.
Pass an order.
I understand. My humble submission, my lord, there is substantial question of law, and it is a reversal finding, not the content finding.
Yes, I'll read it
So
and
maybe
then I'll get to
kindly-
know what type of substantial
May
question
kindly be
law
admitted.
can
for-
frame. Yes. Let's see. I'll have to read it first.
For respondent 4 and
Why you are appealing for respondents,
No,
Kabir?
they are my lord.
for the state of Assam.
No, they.
Notice was served on our office.
Okay.
Yes, Manana, sir.
You want to
No,
say something?
No. But only look at their plane was allowed, I think, in the original.
Okay.
That is what I could recall.
I'll read it. I'll have to read it because it's I cannot assess the judgment so instantly. There are two judgments, very long judgments.
Yes, wait, that I cannot be.
I need to
Both
read it.
judgments are
And
qualified.
then
I mean, the appellate court had is found this sale deeds to be invalid or something, my lord.
undervalued.
No, it is said to be
Undervalued also.
illegal.
It's not complete.
Yes. And void. It was found to be void by the appellate court. So that is how we are connected, because that is registered in our office.
Yes.
Yeah, they are issuing sale permission by the deputy commissioner, so they are made party. And the municipality has been made a party because they have given the.
Correctly
number.
made party.
So it may be admitted.
Because the sale deed is in question, that is why correctly made party.
And the facts of the case is not proper for us to get involved. We are the state.
Yeah, true, but maybe because of the sale deed.
But there, my lord, if there is questions, we will see later.
Yes. But order pass up কৰি দিম পঢ়িব লাগিব মোৰ ডেট এটা দি দিম পাৰি পিছে দি দিম পাছত ডেট এটা I'll give you a date later. It is for orders only, so hearing on orders, we'll fix a date on that same heading under a hearing order 41 rule.
And my lord, senior, the Munship judgment is very expensive judgment and very nicely discussed every point of law, my lord. But the appellate court has made out their own case.
Yes, I have noted down.
He has made out their own case, which is neither party case, nor in the pleading, nor issued to that effect.
I have noted it
But
down.
my lord, writing a stamp paper, processes are there which can be corrected at a later stage also.
Yes,
There,
true enough.
venue is there. So if that can be solved that way, we will go for it.
Okay.
No,
They can always pay
That is
the.
not the payment of any stamp paper. The government has decided to fix the rate of the land. property and we have paid good price. That is the procedure, my lord. I may make a contract for 1,000 copies of post of rupees. That is depend. But what government is fixed, on that we have to pay the stamp paper. And we did, you will also see the last page, 299. 299 page, there is a permission issued by the Deputy Commissioner, my lord. Last one.
I'll note it down. I'll look at it.
Last
Look
one, my
into
lord. It is self permission, my lord.
Page 299, no?
294.
Page
294.
294.
Last page. Self permission issued by the Deputy Commissioner. On the basis of it, we have paid the stamp paper. If Learned appellate court has the agreement, at what amount we may be agreed, that is outside. But what government has fixed, we have to pay stamp paper on it, my lord. And we did it. Moreover, it was not challenged in a lower court. No appealing. Okay.
State of Assam is 4 and 6, man. 4 and 6.
এ লিখি দিবা হা?
I can try for others.
এই হেৰিটো গুচি গ'ল নেকি গোটেই ফাইলে চাইলে গুচি গ'ল নেকি এই হেৰি কজলিষ্ট চচলিষ্ট চব গুচি গ'ল
Please, your lordship,
Mm.
as per office note, this year has been received. Lordship matter may be fixed for hearing.
pleadings are complete.
Yes, lordship. Sure.
Learned counsel Miss
S. Ahmed on the behalf of Miss R. Chaudhary.
S. Ahmed is present on behalf of learned counsel Miss R. Chaudhary. Please stop. Laodima Court's order dated 16/3/2026. Reflects that the postal track consignment report reveals that notices have been delivered to respondent number 5 and 6. One, two, and three. 1 and 2 were earlier represented. The name of respondent number 4 has already been struck off. By order of this court dated 18/2/2019. Notices have already been served on respondent number 1, 2, and 3, which is clearly reflected in the office note dated 22/11/2018. It is submitted by the learned counsel for a petitioner that pleadings are already complete. Full stop. The respondents are not represented today, full stop. The original records, would record LCR দুইটা appellate court দুটা court আছে. As the original records of the appellate court and the trial court are before us, list this matter. For hearing. Okay. After 4 weeks. Date are readable even again, list this matter for hearing on 30 April. Okay.
May I please, Your Lordship? In
Yes,
this
please.
case, Your Lordship may kindly peruse the office note dated 13/3/26. Pursuant to this court's direction, we have taken steps upon 6, 7, and 8. Now, as per the office note, 6 and 8 have refused to accept the same.
Okay.
They have refused the notice. Whereas with regard to respondent number 7, neither the ID card or any answer notice has been received. So in both cases, may I pray that under deemed service under Order 5, Rule 5 may be taken into account, Your Lordship.
6 and 7. 6 and 7.
6, 8,
Those
and 7.
Who has refused, then we can
6 and 8, both
pass
are
out
refused.
for deemed service.
That is deemed service.
Yeah.
And even in respect of respondent number 7, as it has not, because the address was proper. There was,
Do you
because,
have do you have postal receipt?
pardon me, Lordship.
Postal receipt?
Postal receipt, we have sent it through the court.
No, that only if we have a postal receipt, then we can
Because
pass an
I
order
have to
for
take
deed
it from
service
the-
under Order 5, Rule 95.
Then I have to take it from the registry because it was sent through the registry. Office note may
But
kindly,
for the persons whoever have refused, we can pass an order for deemed
6
service.
and 8, Your Lordship. may-
Which date? Which office note dated?
Office note dated 13/3/26.
Okay.
There is a flag, Your Lordship.
13/3/26.
13/3/26. There is a flag given.
All right. Learned counsel, Mr. A. Biswas
Yes, Your Lordship.
is present for the appellants. The respondents are not represented today. Office note dated 13/3/2026 indicates that the respondent number 6 and 8 have refused to accept notice. Thereby notice is deemed to be served on respondent number 6 and 8, full stop. A service report on respondent number 7 is awaited.
And the trial court record has been received, Your Lordship.
Yeah, trial court record we have been received.
Yes.
I can note it down, but if you want to take fresh steps, then you
Fresh
take-
steps means, then we wait for the thing, let the report come.
Okay, awaited, list the matter after 2 weeks. The trial court records
With regard
as
to
well as
respondent
the
number 7.
appellate court records are before us. We have received both the records, appellate court, trial court.
Yes, I have checked it, Your Lordship.
List after 2 weeks.
Obliged, Your Lordship.
Well, actually, it was in the hearing list on 13/3.
Hmm.
My junior could not submit properly. However, now our prayer is that it may kindly be listed for hearing because it is already in hearing list.
But what about the other side?
Other side is not here.
It was already listed for hearing.
Yes,
Okay.
it is already original matter of
The
2007.
appellant is not represented today. Learned counsel, Mr. Amisek is present. You are for the respondent?
I am for respondent.
Okay, learned counsel, Mr. M.U. Borbhia, no?
Mahmood.
M.U. Mahmood. M.U. Mahmood is present for the respondent. Let's just, let me check. Okay. Let's this matter for hearing.
That may kindly be 2007 matter, my lord, original.
Let's this matter for hearing on
A short date.
positively without fail. As this is a long pending case, on failure of appearance of any of the parties, necessary orders may be passed.
Obliged.
Item 8.
The main respondent has appeared, my lord.
Respondent number 1.
My lord.
We'll fix it for hearing.
Yeah, for hearing, my lord.
Learned counsel, Mr.
VK Burma, madam.
VK Bora is present for the petitioner and learned counsel Miss
S. Todi
S. Todi
for respondent number 1.
is present for respondent number 1. What about respondent number 2 and 3?
So they are performer, my lord, my hearing, my lord.
Okay. Respondent number 2 has passed away.
First, my lord. Let me strike off. They are performer, my lord, when we performer, so hearing may be fixed, my lord.
It is submitted by the learned counsel for the petitioner that the main respondent is present and the performer respondent's presence is not required for hearing. It is also submitted that the respondent number 2 has passed away
That's it.
and his name may be struck off.
That's it.
Okay.
That's it.
On submission of the learned counsel for the petitioner, the name of respondent number 2 is struck off at the risk of the petitioner.
That's it.
List this matter for hearing on.
After B. Obliged lordship.
You don't need the LCR.
LCR, my lord, LCR will require.
Then we'll fix it for orders then. Call for the scan copies of the trial court record. There's no stay granted, no?
Stays there, lordship. That is.
The interim will continue.
Okay.
A small date may be fixed then, lordship, if LCR has been
Call
called.
for the scan copies of the trial court records. Interim order shall continue till the next date of listing. List this matter after 2 weeks.
After 2 weeks, lordship.
Item 9.
As per your last order, Your Lordship, in this case, respondent number 1 and 2 both are appeared, and respondent number 1 has taken time for filing affidavit, but after 6 months, they did not file the affidavit till today.
This one number 1.
Yes, I'm appearing for the
You'll
caveat.
file affidavit or you?
Some
take
time may be allowed. Your Lordship, my senior had received some additional documents, so
Okay.
I'm appearing on behalf of Mr. T. Mozumdar.
Okay. And what about respondent number 2?
Yeah, just electricity board here. That was now on last date, he was
They
appeared.
were there. Okay,
Yes, sir.
it's okay. Learned
all
counsel, Mr.
A Hussein, Your Lordship.
A. Hussein is present for the petitioner and learned counsel, Mr.
Mr. H. Bora,
H. Bora
Yes.
is present on behalf of learned
Mr.
counsel.
T. Mozumdar.
Mr. T. Mozumdar, representing the respondent number 2, full stop. The learned counsel for the respondent number 2 has prayed for time to file an affidavit as they have affidavit
An affidavit in opposition.
in opposition as they have received some additional documents relating to this case. Full stop. A last opportunity is accorded to file affidavit in opposition. List this matter after how when do you want?
3 weeks, Your Lordship.
Date may be fixed here.
Date at a direction.
Hello, please.
Obliged.
My lord, I am appearing on behalf of the respondent. As per the order dated 27/2, the court had placed this before the Lauzima court for ascertainment of service. Since I have already marked my appearance, that service can be dispensed with.
Where was it placed for?
Before the registry, Honor. On 6th, the registry, but if you have previous the office note in.
Okay, so not required because you are present.
Yes, Your Honor, I have filed a
Only
wakalat
one
now in the
respondent?
meanwhile.
Yes, no, no.
Only one respondent, Your
Sole
Honor.
respondent.
Lordship.
Your name?
P. Gogoi, Prasanto Gogoi.
Do we need the LCR?
For the request.
Do you want LCR?
My senior instruct me to fix this matter for admission hearing.
For admission.
Here.
Meanwhile, we may grant 4 weeks and we prepare a file our affidavit in opposition for this.
Let them file their affidavit. Meanwhile, let us call for the scan copies of the
Yes,
records.
a scan copies would do.
To be on the safer side. Learned counsel, Mr.
P. Gogoi.
P. Gogoi is present for the petitioner and learned counsel, Mr. N.R. Surana.
Surana.
N.R.
NR Surana.
N.R. Surana is present for the respondent. Full stop. The learned counsel for the respondent has prayed for time to file affidavit in opposition. List this matter. You want a date?
After 4 weeks, If convenient to then it could
Place this
convenient.
matter after 4 weeks. Meanwhile, call for the scan
Yeah,
of child court
interim order
records.
will continue for till death. Interim order to be continued.
Okay. Interim order shall remain in force till the next date of listing. Child court records?
Yes.
Yes.
Obligation.
Please, Lordship.
Hmm.
Lordship, this IA was for correction of the address
Hmm.
and notices were being served upon them.
Hmm.
As per office note dated 9/1/26. Notices have been served and they have not appeared.
There you,
What are respondent numbers 1, 9, 10, 11, 12, 13, and 14? My lord, actually, I have not received a copy of the IA as of till now. I don't know what the IA is about.
I about the correction of address.
whose address?
Respondent number 22-2 to 22-5.
Correction of address in the main appeal.
Yes, main appeal.
You can correct it.
Yes, notice appeals also, they may be given expertise in this matter. have not-
Address can be allowed to be corrected.
Yes.
Earlier, they were present in
No.
the other case,
In the trial, they were present.
not in the
Other-
trial.
Sorry.
You have given a new address,
Yes, new address.
not according to the child court records.
No.
Give them a copy.
Yes,
You want to submit on the correction of address?
If lordship deems it necessary to allow it, I can allow it.
You have no objection. Heart Learned Council, Mr. Unit,
S. Afridi.
IA number 2733.
Yes.
2733 2025. Heard Learned Council, Mr. S. Afridi, for the appellant stroke applicant who has filed this application for correction of addresses of defendant number 22 within bracket Roman 2 small I data bracket close to 22 within bracket small v bracket close. তার মানে 2 পৰা 5 লৈকে in view of the order dated 39/2024 passed by this court.
Yes.
Which order?
I have annexed the same, page number 12. It says on page number 18. On perusal of the office note dated 23/9/24, it appears that the notice issued to respondent number 22-2 to 22-5 has returned with endorsement that the address is not residing in the given address. In view of the same, Learned Counsel for the applicant has paid for some time to find out the proper address of the said respondent to take
Okay,
steps.
all right. In connection with passed by this court, order dated, what is this? 39/2024. In view of the order, this is 39/2024 passed by this court or court in connection with
RSA number 5.
RSA number 5 of 2024. Okay. Marked as more particularly annexure 1 of this application. For Subordinate Counsel, Mr.
Yeah, I'm appearing on behalf of respondents 1, 9, 10, 11, 12, 13, and 14.
लिख ले।
1, 9, 10, 11, 12, 13, and 14.
Notices have been issued to the other respondents An office note dated 9/1/2026 indicates that notices had also been served to respondent number 22 within bracket small two মানে হেৰি small I দুটা 22 they have received the notices.
Yes.
Why do you want to change the address?
No, no, now they have received, in the IA, I have to send the notice since the order was not passed in RSA, so we cannot send the notices through RSA, the RSA one.
Or it
That is why.
in that earlier address or in the new
No,
address?
in the new address.
New address, okay. 22/2 to 22/5 in the new address.
Yes.
But the respondents are not represented today, full stop. The learned counsel for the respondent who is present today has no objection, full stop. Considering the submissions at the bar and considering all aspects, the application is allowed and the addresses in the and the new addresses may be allowed to be replaced by the and the new present addresses may be allowed to be replaced after deleting the earlier address mentioned in the appeal memo. Full stop. Where is the new address mentioned? In which page?
Page number 9. Second paragraph.
Page number 9, no?
Yes. Second paragraph. Present address of the respondent number 22/2 to 22/5.
এইটো page number 10 or আছে. It's in page number 10, I think. Page number 10, last paragraph, second paragraph.
Para 2.
The present address of the respondent number 22 to 22/5 mentioned as near Royal Place, Srimanto Sankar Nagar, Pathor Quarry, Magazine, okay?
Yes. Yes.
Number 76, Namghor Pot, PO -Uday Bihar, District Kamrup M, PIN 781171, phone, it will give you a phone number too, is allowed to be typed and replaced in place of the earlier address given in the appeal memo.
Yes.
In terms of the above observation, this application stands disposed of, full stop. An amended appeal memo to be filed in RSA number 5 of 2024. RSA number 2024 to Lihidia list this matter after 2 weeks.
Maybe after Bihu, Lordship.
Yes, sure.
Yes.
List this matter after 4 weeks.
Lordship, I think the respondent number 19, the notices have not been served. So I will be allowed to take steps upon respondent number 19.
Of course.
Yes.
Yes.
And there is one mistake actually in the earlier order, which is the same order 39/24. Actually, due to some typographical error, it was written 22/2. It should have been from 22/1 to 22/5.
But
So
you are paying
maybe-
for 22 to their husband and wife, it's okay.
I will be allowed to take steps upon the 22 to 1 as per the address of 22 to 22 5.
You can take steps. They are husband
Well,
and wife.
Yes, but
I can allow only the prayer you have prayed for,
Yes.
not more than that.
Okay.
I have allowed only your prayer. Your prayer is 22-2, and they are spouses, so you can take steps.
Okay.
Mm.
May I please your Lordship? Well, I take the last office note matter. This is a transfer petition filed with your wife from Hailakandi to Silchar. Because of she's not getting any maintenance and ailing father, she cannot come to the Hailakandi, leaving a son minor. We prayed for a stay order. Your Lordship said that after their appearance it will be considered. But in spite of the fact that notice has been served as per office note, they are not appearing.
Good, we'll hear it and dispose it of them. Service report of notice issued by Peace Board, neither ID card nor answer notices have been returned. Journal was consignment checking details found may be seen it as per details notice appears to be delivered. Notice has been delivered.
Delivered. So willfully is not coming so that, and I am also, because of this pendency of this case, I cannot go.
We'll pass an order next date. We'll fix it for admission and pass an order. Learned Counsel Mr. S.C. Biswas is present for the petitioner. Stop office note dated 11/3/26 indicates that the consignment tracking details found in India Post website reveals that notice has been delivered in the given address. Full stop. Notice is thereby deemed to have been served. List this matter in the admission column.
Till then, my lord, further proceeding may kindly.
We'll dispose it on that day.
It will take time, my lord. The ladies.
It won't take time. It won't take time. We'll dispose it.
Then the date may be fixed, man.
List this matter in the admission column on
This month, but
21st of
no, this month, if possible.
21st of March.
All right.
I did 30.
Made pleasures. Well, I filed this case for transfer of the petitioner's case from the family court principal judge to Sonitpur Tezpur. The Lordship admitted the matter, heard the matter on 4/2/26, and it was made returnable within 4 weeks. And till then the matter was stayed, and the record has already come before your Lordship, family court's judgment.
We'll fix it for admission there. Nobody has been served.
Notice has been served.
23/3 we give that to. No, notice is not served. No.
7 to official report is there that it has come back.
With regard to notice issued by way of speed post, neither AD card nor answer notice has returned till date. No. No, sir. It will come again. Learned Counsel, Mr. Your name?
My name has not been shown in the cause list, Lordship.
Has not been shown.
Yes, it may be shown.
Mr. N. Ahmed is present for the petitioner. So it is submitted that you have submitted Wakalat Nama.
Yes, I have signed.
It is submitted that Wakalat Nama. It is submitted that Wakalat Nama has already been submitted by the Learned Counsel. Post of registry to reflect the name of Learned Counsel Mr. N. Ahmed in the cause list. Office note dated 23/3/2026 indicates that notice service report on respondent is awaited. Scan copies of the trial court record has been received. The interim order is extended till the next date of listing. List after 4 weeks.
Fixed date.
Fixed date, date that detail.
28th of April. Of that years.
May it please your lordship, I'm appearing for respondent 126.
I,
Yes, your lordship.
this is for delay condemnation.
Condemnation, setting aside abatement and.
You want to file any objection?
Yes, your lordship.
Applicant is not represented today.
On last occasion also, they have not appeared, your lordship.
No point. We can
Um,
dismiss it, but again, they'll file a petition for restoration, again, abatement, whatnot.
One more chance.
Yes. Full stop. Order dated 13/2/2026 revealed that appellant was not present on the earlier date. Full stop. On failure of appearance of appellant on the next date, applicantly, but the appellant on the next date, necessary orders will be passed. Meanwhile, learned counsel Miss
S. Sharma.
S. Sharma is present for the respondent.
Respondent 126.
Respondent 126. Any other respondents?
No, your lordship.
Full stop. List this matter on
Lordship, after 4 weeks.
after 4 weeks. Okay.
Alleged.
Yes.
My lord, see, my lord, first the order dated 8/11/2024 at page 12, my lord.
Which one?
In the petition, my lord,
8/11?
24.
Which their main petition?
Main petition, page 12.
Page 12. Okay. 8/11/2000?
24. 8/11/24, yes. Well, my the guardianship petition before the trial court, by the family court, that means, my lord, was dismissed for default, my lord. That is on 8/11/2024. Petition is absent without steps, opposite party present, reviews the case record. It reveals that the on the last 2 dates, the petitioner was absent with step, and today petitioner was absent without step. Hence, heard the opposite party, considering the above, I am of the opinion that the petitioner is not interested to proceed with the instant case, and as such, the instant case is dismissed for default of the petitioner. Then, my lordship may come to page 13, my lord. We file an application, my lord, for restoration of the petition on 30/3/2025. And this petition, my lord, we have stated the grounds, my lord, because his father was ill. Because of that, he could not took the steps, my lord. Then page 25 may be seen, my lord.
This IA for?
IA for modification of the marriage, there is a child right to visit, my lord. Because they have against the restoration of the petition, they have approached this court to against that order, my lord. And the honorable court has.
This application was under order 9 rule 9.
Yes.
Order 9 rule 9.
Yes, my lord.
Yes.
It was for.
Any order was passed? No.
This honorable court was pleased to.
Lordship may see
issue
page 18, my
notice.
lord. Page
And
18 of my.
That lower court proceeding was stayed by this honorable court. And so far, my learned senior counsel has filed this for partial modification of the order of this court.
My right to visit has
Right
been
to
stopped
visit.
because of that, because I'm paying
In the
maintenance.
IA page.
I want to see my child. So because of the stay order, this the wife has stopped.
To
the
that
visit the
extent,
child.
my lord, that can be modified. To that extent, regarding the visiting of the child.
And the lordship can hear the petition, my lord.
And that may be fixed for hearing of the matter. And in the meantime, that still will continue in terms of the lower court proceeding.
Okay.
Only if this
Child
modification.
visit as per the
Side visit.
earlier order, my lord, of the trial court order. the
Side
family
visit,
court order.
why not to that extent?
Okay. Our learned senior counsel, Mr. P. Roy, no?
J.
J. Roy, for the applicant who has filed his interrogatory application with way for partial modification or stroke clarification of order dated 5/1/2026 passed by this court in civil division petition bracket IO bracket close number 538 2025. Order dated, which order?
Dated by this honorable court order.
5/1.
Yes.
It is submitted that by the order dated
5/1/26.
2026, the proceeding of
The trial court was
The guardianship case, my lord.
in,
Ms. J case.
yes,
Ms.
Ms.
G
Z case. Ms. Z case, my lord. Ms. Z case number 131/2022.
Ms. G case number 131 of 2022 has been stayed.
Yes.
Post of the applicant, who is the father of the minor,
Minor child.
My-
is being highly prejudiced as the applicant who is paying the maintenance for his wife,
Right.
child, or wife also.
Wife child.
For the child only.
For the child.
For his child has been debarred from from his visitation rights to visit and meet his child.
Yes, ma'am.
Full stop. The learned counsel, Mr.
D. Bora, your lordship.
D. Bora is present for the respondent wife
Wife.
and has no objection if they the order of stay is modified to the extent that order of stay dated 5/1/2026 is modified to the extent that the applicant is allowed to visit his child according to the earlier order.
Earlier lower court.
In which case, earlier order
Earlier
passed by
Order in the Ms. case Z 131/2022.
passed by the family court
Family
in
court.
Ms. G case number 131 of 2022.
22.
Whereby and whereunder the applicant was allowed to
Visit his child.
Visit his site.
visit its child under certain conditions.
It order annexed or an.
The lordship will refer to the order of the court, my lord.
Okay.
Well, whatever the condition is there, my lord.
Under certain conditions framed, formulated by the
Right.
learned family
Family
court.
court.
Full stop. Considering the submissions of both the sides, comma, this application is allowed to the extent that the application is allowed to the extent that the applicant, i.e. the father of the child, is allowed to visit his child according to the conditions formulated and imposed by the learned family court
Yes, ma'am.
in connection with Milji case number 131/2022. In
This
terms
order
of
will
the-
come into effect immediately because then he will visit his child.
Okay, in terms of the above observation, this application stands disposed of. Yes.
With immediate effect, my lord, so that.
Yes, yes, with immediate effect.
Immediate.
Well,
Lordship may fix the
The main
matter.
case, my lord.
Sorry,
The main case.
Main case, lordship may fix for
Main
hearing.
case may be
This-
fixed
this
after
matter-
3 weeks.
parties are represented, list this matter for hearing, for admission, no?
For
Or
admission.
it will.
For admission after 3 weeks. At the stage of admission, we can dispose. of
Yes,
that.
yes.
Obliged.
Obliged.
Regarding RSA, your lordship, delay.
Delay, will issue notice. Dr. R. Sharma is present for the applicant. Gustav applicant to take steps to issue notice to the respondent. List after 2-3 weeks. List after 3 weeks. Okay.
Obliged. I'm the last man standing here.
That's yes. But it's over, thankfully.
Yes.
Yes,